Good morning, Mr. Corbo.
Good morning, Chief Justice Marshall. Good morning, Associate Justices. My name is James D. Corbo. I represent the juvenile known by this court as Porter P. Assisting me today at council table is Attorney Rachel Scott, who assisted me with the brief. I'm asking this case comes to you from the appeals court reversal of Judge Leslie Harris's allowance of my motion to suppress evidence. This court allowed my motion for further appellate review, and I'm asking the court to affirm Judge Harris's ruling that my client and his mother had a right to privacy in that locked bedroom in the family house shelter.
I'm sorry, go ahead.
What about the fact that your client's mother had agreed to be governed by the master plan that said that the staff could have access to their space?
Your Honor, I asked you to look at Como versus Nielsen, the Fitchburg State case for
But that was the facts there were very different. The individual in Nielsen could rearrange his furniture in the room. He could have guests in the room whenever he wanted. He could have food in his room. He could have valuables over $100 in his room. It was a totally different situation.
Right,
I
and
don't
this
see
case
it as
is
analogous at all.
Well, this case is a very different situation, and I submit to the court, not only is it a case of first impression for this court, it's a case of first impression for the country. And what the appeals court did was they took this square peg of somebody living long-term in a shelter, and they pushed it through the round hole, applying past precedents, which are totally different. And in this case, my client and his mother lived in this shelter in the bedroom. And when they left for the day, as they were required to do, the mother was required to leave to look for housing, she locked that door. And the staff is allowed, the director, as executive director, not as a cohabitant or a co-tenant, is allowed to have staff go in at her direction to make sure they're complying with certain things, which they have to do, given that there are 24 rooms and there are 24...
But one of the things they're supposed to do is comply with the laws.
And no gun policy.
No gun.
Right.
So she has permission to go in to make sure that the laws are being followed.
No, the policy simply says you cannot have a gun in the shelter, you can't have drugs in the shelter, you can't break the law. That does not give... does not mean that my client and his mother waive their constitutional rights by being put into the shelter to the government.
All right, but you don't say, take the police out of this. I mean, would there be any problem if Ms. Brown, that was the name of the director,
Yes,
right?
Ms. Cynthia Brown, yes.
If she hadn't been nervous about the gun, and she had done what she did with drugs. She'd used her key, she'd gone in, she'd searched, she'd found the gun under the duffel bag in the closet herself, and then had given it to the police.
Right.
Would that be a problem?
No, because there's no
Well, are
government
you
search.
arguing, yes, but then are you arguing that private citizens should have to go in and take a gun, which may be loaded and the safety may be off, and have to take and hold a gun and have it around other people in the shelter?
No, they don't have to because
But
they...
you just said the woman could go in and take the gun. For all you know, the gun would go off when she picked it up. Or she knew the gun would go off when she picked it up.
She did the right thing. She called the police, and Detective McLaughlin had probable cause to apply for a search warrant. And that's what should have happened. She did the right thing. She called the police. She got their assistance. They investigated over several days. And at that point, the law requires them to get the search warrant. And essentially, what the appeals court said was basically that if you're living in this controlled environment, and I want to take away the word homeless, they live in a family health shelter, they meet strict requirements to get into the shelter, but this court's decision, and I ask you to look at the privacy rights in this case, applies to much more than people living in homeless shelters.
Yeah, that's fine.
But why couldn't the police do what Brown herself could have done, where she accompanied them and essentially watched them while they did what she herself could have done?
Well, the difference, Justice Spina, is that she is the law requires consent. Okay, the privacy issue, I submit to you, is there is an expectation of privacy that's objective. at
Let's
that
assume
point.
let's assume that's the case.
Yeah,
Right.
Let's assume the
That's a
appeals court's
question
wrong.
in this case.
Let's move to
Yeah.
this other issue
Let's
of
move to the consent issue.
authority.
Yeah.
Well, then at that point, all the precedent, both in the U.S. Supreme Court, this court, other states, is all the factors look at cohabitants. It's the boyfriend, the wife, the guy sleeping on the couch, is he a cohabitant? There's no other, the only other precedent, if you look at Nielsen, is the administrator of a college, because they have the right to go in and do that. This court said that does not mean that they can simply waive the constitutional rights of somebody living under their care. And
What did the residence manual say?
the manual said that in terms of the weapons, Justice Ireland, or
No, access to the rooms.
right, that because it's a small space, they have to make sure you don't have you're not cooking food in there, it's not messy. That they can let professional staff in, meaning like cleaners or painters, as a landlord could, and that there was controlled access where the director could allow staff in at a certain time, and that there would be room checks where there'd be an announcement.
Not at a certain time, any time,
Any time.
to inspect for health or safety issues or failure
Right.
to comply with the other regulations
Right.
of the house.
For the staff, and balancing that as a privacy issue. If you or I were to go out on the Columbia Road this morning and knock on that shelter, we would not be allowed in. If we ask who would live there, we'd be told that there's a privacy
Because we have no
policy.
authority to get in, but certainly if we went to the executive director, and she would have authority to enter any of the rooms
Right,
to
but if
inspect.
we asked her who lives here, she would say, there's a privacy policy. I cannot tell you who lives here. And in balancing, if you look at the manual, there is with the responsibilities, there are rights which help serve to let people become self-sufficient and move on and get housing. And what I'm asking the court to look at is the consent exception focuses on when you choose to live somewhere, and whether it be with a friend or a loved one, you assume the risk that you give up privacy when you live with that person, that when the police come to the door and they knock on the door, your roommate will let them in. And that, I think, if you look at the reasoning of all courts, it's an expectation that you assume again with that privacy. And what I'm asking the court to find...
Why wouldn't that assumption apply here, where you go to live in a place under rules and regulations that govern what you can have in your room, require personal items to be inventoried, require you to be out of the room from 9 to 3 every day, a whole laundry list of very exceptional terms which really limit your control over your space and really maximize the control in the manager. Isn't that something
Right,
we should take into
but the difference, Justice Cordy, is the locked door